Firstly, good morning, everyone, and welcome to this, the third in our current series of Gowling WLG ThinkHouse Brands and Designs webinars. In the previous webinars, we've looked at advertising in the current pandemic and at the response of brands to a time of fast-paced disruption and social change. If you missed them, both previous webinars are available on our website, and we'll also be emailing around a link after this session. We do also have a fourth webinar in the series coming up in the new year with our colleague, Kami Salhan. Kami will be discussing what every business needs to know about the often overlooked right of copyright. So do look out for an invitation to that in the next few weeks. As in our previous sessions, we really welcome your input during today's webinar. So please do submit your questions via the Q&A function at the bottom of your screens. We'll either try and pick them up as we go along or at the end when we've factored in some time for questions. I'm really sorry if we don't manage to get to every question during today's session, but rest assured, if we don't manage to cover your question, we will follow up with you afterwards. I've mentioned the two previous webinars in our series. Those of you who tuned in will have spotted that John Coldham chaired both of those previous sessions. Well, today it's John's turn in the hot seat. John is the head of our UK Brands and Designs practice here at Gowling WLG. He's described by the legal directories as one of the leading design rights experts in Europe and a go-to person for design disputes. Today, John is going to give a brief recap of the current design protection landscape and then talk about his recent win in the Freddy and Hugz case. He'll finish up with the impact of Brexit on design protection and some practical pointers on what this all means for your businesses. So, John, I'll hand over to you.
Thanks, Matilda. Hello, everybody. Good morning. As Matilda said, I'm going to start with a bit of a recap about designs. Excuse me. There's quite a mixture of different people who've dialed in today, and so I don't want to make it too complicated too quickly or too simple for everybody. So there'll be a bit of a mix in subject matter. As Matilda said, we're going to start with a reminder of the importance of designs and what basically they're all about, because there's so many different types of design and different ways of protecting products and brands and so on, that we need to make sure that we get a good picture of what they're all about before we go into any detail. Then I'll talk about the Freddy and Hugz case, then I'll talk about Brexit, excuse me, and finally I'll talk about what it all means for you. Now, designs are relevant to a lot of different types of people. They're relevant to people who do product design. They're relevant to people who do logos and things like that. So basically every type of business could have at least some form of design protection that would be useful. There are some businesses which may not need huge amounts of design protection, but it's more than most people think. So moving straight into the different types of design that we have now. Big caveat, I'm afraid I'm going to keep mentioning the B word of Brexit. This is all going to change at the end of the year, but we'll look at how it's going to change later. And the basic ingredients are staying the same. Looking at first of all, looking at the unregistered picture, I'm going to try using a laser pointer. Please forgive me if this looks terrible, but I'm going to try and do it just to point at different things as we go along. The top one is UK unregistered designs. These are designs that protect the shape of something, only the shape, and we'll look at that in a lot more detail when we talk about the Freddy and Hugz case shortly. These last 10 years, and they obviously are only applicable in the UK. Moving around to the left, to the grey circle, there's unregistered community designs. At the moment, if you first disclose your product in the UK, you will get both the UK unregistered designs and the EU version, which is the unregistered community design. However, they are very different rights. The European version only lasts 3 years, but it protects every aspect of a product. It protects, or it doesn't even have to be a product, it could be a logo or a pattern. It protects the shape, but it also protects the color, the material choice, the lines, the contours, everything. That's the big difference. UK unregistered designs are therefore seen as potentially being more broad in that they only protect the shape. So if you have something like the G-Star case that I did a few years ago, where actually some of the alleged infringement products were actually made of a completely different material. So they were more like chinos than jeans, but because it was all about the shape, that didn't matter. For the EU version, that would have been more relevant. Looking at the bottom left, there's also copyright. Copyright is obviously different to design right, but UK unregistered designs, for example, were sort of extracted from copyright in the first place. So copyright is something to think about when talking about designs. As Matilda said, Kami's going to cover that in January in a specific session about copyright, not just of products, but also copyright more generally. So I won't cover it in detail here. Suffice to say that the case law on copyright is moving towards more products, articles of applied art, as they call them, which may be protected by copyright in a way that perhaps previously people didn't think that they were. The European courts would say this isn't a change of the law, it's just a clarification, but we all know what the Europeans think about things like that. Looking at registered designs, there are two types. And that's obviously on the bottom right of your screens. There's UK registered designs and registered community designs. As it's harmonized, both are basically the same thing, apart from the geography that they cover. The registered community design currently covers the UK as well, but obviously will cease to apply in the UK after Brexit. And when we talk about Brexit, we're talking about the end of the transition period, which is the 31st of December 2020. I'll talk about the changes later. I bet you can't wait. It's a nice thing to look forward to on the talk. But in the moment, I'm going to talk about the current position, which mostly applies after Brexit as well. Oh, my pointer means I now can't change the slides. Give me 2 seconds. There we are. Right, the value of registered designs. Why would you consider registered designs? Well, first, in the UK and the EU at least, they're cheap. I'm only talking about the application fees now, not any fees you might have if you go to a design attorney to get a registration, although they don't tend to charge a lot of money either. The UK application fees can be as low as £2 per design. And the EU version, bearing in mind that it covers, even after Brexit, 27 countries, is as low as €80. If you file just one design on a single day, then you will pay more than that per design because their first one costs more money. In the UK, the first one costs £50. But if you apply for, say, 10 on the same day, the ones from 2 to 9 are a total of an additional £20. And so it goes on. If you file 20 on the same day, you're looking at a fee of £90 in total. EU, similar idea on a slightly different cascade. So don't let the cost of registering your designs put you off. In fact, the cost is such that you can think of some reasonably innovative ways of protecting even one product with several different potential design rights. They last a long time. They last 25 years. For lots of products, that may be far more than you need, particularly in the fast-moving consumer goods sector. In that area where you may decide that actually you don't need it for 25 years. So when the renewal fees start coming in at 5 years in, you may have done everything you want to do with your design by then. And you can make a decision at that point whether to pay more to continue the protection or whether to leave it. Some products, obviously, you have to register it at the very beginning and you don't know at that point whether or not the product will be a success. So knowing that you don't have to pay the fees to cover the whole 25 years up front is an advantage. This is much longer than unregistered designs. I've already said they last between 3 and 10 years. So this is quite significantly longer. After launch, you can still apply for a UK or EU registered design. There's a 12-month grace period, which means that if you want to take your product to a trade show, you want to show it around, see whether there's any appetite for it before seeking to register your design, you can do that. However, it's not something that I recommend unless you have to. Excuse me, the reason for that is twofold. One is that they're quite cheap to apply for, so just get the registration in first. And the second thing is, what you can do is if you file your UK or EU registered design application, you then have a period of 6 months before you have to apply for your registrations elsewhere in the world, where the application fees are quite a bit higher. Therefore, you've got a little bit of time that you can buy before you then go to other parts of the world. So it's quite popular to register in the UK first. A warning though, if you rely on the grace period, that may limit your options for internationalizing your design later, because they will apply their own law as to whether there's a grace period in their country before moving to register your design. So if you've relied on the full 12-month grace period here, and the other country that you're trying to go to does not have that grace period, then you won't get protection there. So my general advice on this is not to use the grace period unless you have to, but to bear it in mind so that if you have disclosed it in advance of seeking any form of protection, bear in mind it's not too late, and you can probably salvage at least the UK and EU, even if you can't necessarily get protection in some other parts of the world. But it's an area to get advice on. What are the other advantages of registered designs? Well, the main one for me is, well, the two with the grey edges are the most important things, really. One is they're very effective for online takedowns. You can use unregistered designs for online takedowns. You can use other IP rights like copyright as well. But having a registration that is presumed valid is a useful thing, because you can waive it at the platform and they will take the product down if they think it's too close without asking too many more questions. If it's an unregistered right, you need to explain more, it costs more money, and it takes more time. Likewise with settlements, registered designs get a bad rap because when you get to trial, they're quite often unsuccessful. Not always, but quite often. And the reason for that is because the trickiest cases get to trial. In our experience, registrations tend to lead to faster and better settlements. That is because the defendant would have to prove that your registration is invalid or that it doesn't infringe it at trial, which is obviously an expensive step for a defendant. Therefore, if you have a certificate, they tend to, not always of course, they tend to be more amenable to finding some form of compromise. Whereas with unregistered designs, it's just that bit easier to seek to challenge the basis on which you're bringing your case. Looking at the perceived drawbacks of registered designs, and there are some, you need to use them for the right scenarios and not the others. The first one is that they are, as I just said, generally interpreted pretty narrowly. That's not always the case. If you've got something that's particularly revolutionary, then it may well be that it has a reasonably broad arm of protection, but not always. So they are relatively narrow. And there are ways to make the most of that, or to get around that problem, and we'll talk about that in a minute. The other problem is that you have to register and define your scope of your design before you have any idea how somebody else is going to try and rip you off. This is a problem, because obviously you could include a feature in your design that you were pleased with at the time, but people can design around it. They can look at your lamp with a round lampshade and they can decide to make it hexagonal. They can take all the other features, but if you've included the lampshade will be taken into account when considering the scope of protection of your design. It doesn't mean that one with a hexagonal lampshade won't infringe, but obviously it's a notable difference that the court will take into account. Now, if you, the third point on this slide is that if you do register a lot of designs, then obviously even cheap designs add up if you buy enough of them. I wouldn't personally consider this to be enough of a problem for most businesses, but obviously if you're a startup, these costs can still add up. It's something to bear in mind, but there are ways to manage that cost. One way to manage that cost is to go for UK only in relation to as many designs as you can, where you can get as much as 100 designs for £250, and then think carefully before internationalizing or before renewing. You should have a pretty good idea that if you haven't made any money out of your registered design within the first 5 years, whether you're going to make any money out of it going forward. So before you fork out for the renewal fees, you can try and manage those costs. But it does require you to really think about your portfolio and manage it actively, so you don't accidentally end up paying out for things when you're not really using them. Finally, you just do have to be careful if you are filing lots of designs, maybe for different iterations of your product, that your earlier product doesn't invalidate your later and better design. That requires you to have a bit more of a strategy about how you're filing your designs. So if you know there's a tweak coming that's going to make your design that much better, you don't want to file the early design too early, because otherwise you could end up taking the majority of your later design out, meaning that the tweak is not protectable on its own, but together it would have been a stronger registration than if you'd filed too early. So how do you make the most of your designs? Well, I know if you've watched these seminars in the past, I have talked about trunky cases a lot, and that's because they were the subject of a Supreme Court case a few years ago. But here are 3 different versions of what is fundamentally the same product. The middle one is actually a slightly earlier version. I would recommend filing multiple designs for the same product. You could do it like this: a photo, a CAD, and a line drawing. Those are, if you file them on the same day, legitimate different designs. But you might also want to protect just parts of the design. If you register these sub-designs, different levels of detail or different parts of the product, then that means it's harder for somebody else to design around your product. Obviously, each of the sub-designs has to be protectable in its own right, i.e. it has to be new, so you can't go down to the infinite detail, but you can think about how to split that design into different elements. Putting yourselves in the shoes of the infringer is not a bad way of doing things. One thing that Apple did when it was registering its first ever design for the iPad was it registered some thicker versions of the iPad. Don't forget, you don't have to use the design yourself to keep it. It's not the same as trademarks. It registered thick, as far as I understand it, the reason it registered thicker versions of the design was because it knew that it had patents on all of the miniature little components that made up the first iPad. And it knew that its competitors would necessarily have to make a thicker version of the iPad in order to be able to sell it and not infringe the patents. So they registered some designs for the thicker version of the iPad to make sure that they had that covered. It wasn't actually successful in the fullness of time because it was decided that the design for the iPad was still too simple. But the idea was one that can be borne in mind by other designers. So to summarize how you make the most of registered designs, using a bank of UK designs as a springboard for wider geographical protection of a subset of them is a really good way of doing it. Get the big bank, whether you're a UK business or an overseas business, it doesn't really matter. Anybody can file a UK registered design, provided you have filed it nowhere else first, unless you're relying on priority. I would recommend you use a bank of UK registered designs, and then from there expand out to different geographical jurisdictions where you feel that is helpful. Also consider which parts of the product are worthy of their own protection. Use the cheapness of designs to your benefits to register those sub-designs as well, and use dotted lines to exclude those parts that are not protected by the design. I saw a good example of this once where it was a design for the sole of a shoe, and the one groove in the sole of the shoe was protected as a design right in its own right. Why? Well, it was actually quite an intricate design in itself, so it survived the attack that it wasn't particularly new. But what happened was that the client had used it as a sort of chevron going up the shoe, but by protecting just that one chevron with all its detail and dotting out the rest to show that it was in the context of the sole of a shoe, what they did was they managed to catch somebody else who'd used the same chevron but had used it inwardly. I think I may have got that the wrong way around, but either way, they took the groove, but they took it and used it quite differently on the shoe. Now, had the chevrons been pointing inwards rather than outwards, it's a question whether or not that would have infringed if it had been for the whole sole, because they were quite different in that respect. But the groove was exactly the same. And by protecting just that one groove, they had a stronger case. Do be careful, though, final point on this, on the use of colour. Lots of clients of mine and lots of people I've seen out there use colour because they don't think about whether or not that level of detail is a problem. CAD software quite often uses, for example, a blue for shading or something like that, just to show the contours. It's not intending to limit it to the colour blue. If you do include blue in your product, it won't be fatal to a case about other parts of the design, but it will be factored in. And I had a case last year for our client Schnoggle where the blue contours were seen as being part of the design, and that was not intended. So just be careful to exclude any levels of detail that you think may distract from what you're trying to protect. Now, that's enough about registered designs for a bit. So let's look at the value of unregistered designs. Now, it's pretty simple. They are free. That is a really quite a valuable thing to think about in relation to designs. But as I've said, registered designs aren't that expensive. So that is probably not enough in itself to justify you thinking about it too hard. The real advantages of unregistered designs is that if you qualify for them, and we'll look at that later, they're pretty broad. the unregistered UK design, as I've said, covers just the shape. So there can be lots of other differences, but if the shape's the same, it infringes. We did a case a few years ago about showers where the infringement was opaque white plastic and the original was glass. They looked to the consumer quite different, but not in relation to the shape, which was very, very similar. And so it was found to infringe UK unregistered designs. They're also, looking around the other side of the circle, they're also pretty flexible. You can define the design that you are relying on at the point at which you've got the infringement in front of you. So that's the point at which you can do the exercise that in registered designs you have to do at the beginning to decide which bits of your product were the key ones that have therefore been taken by the other side. Some cases you've seen defendants arguing that that's not fair in some way, that why should you be able to craft what is effectively your designs after you've seen the infringement? And judges have been pretty unanimous in saying that that isn't the way it works. You have the design beforehand, you're just defining the legal scope of it after the event. And as long as that design is new in itself and is not commonplace, then it is a perfectly legitimate way of doing it. Obviously, if you get it down to the square top of a box and nothing else, then it will fail for not being new and interesting. And as I said, they last between 3 and 10 years, depending on whether you're talking about the EU version or the UK version. The EU version lasting 3 years is a frustratingly short amount of time. By the time you've first marketed the product and you have been copied and you've sued them and you've gone through to the trial, the odds are most of that 3-year period will have been used up. Therefore, if you are in the sort of sector like fashion, where you might want to rely on that sort of right, you need to think about whether you're most likely to use it for an injunction, in which case, of course, it's more likely that the 3 years will be useful, or you want to think about coupling that with a couple of registrations. Looking at the drawbacks of unregistered designs, the first one is that you need to prove you own the rights. If you have a registration certificate, then obviously you own the rights because they it's written on the certificate, and somebody has to challenge whether that certificate is right. With an unregistered design, I can count on 1,000 times the number of times you write to people about an unregistered design infringement, and the first thing they come back with is prove that you own it, and you have to go through your records. So one of the most important things to do is to ensure that your paperwork is in the right order to show that you not only qualify for the rights, but you own them as well. So that brings us to the second circle, which is how you prove that you qualify for the rights. This is almost a talk in its own right, so I won't go into it in too much detail. Suffice to say that basically, if it's a UK unregistered design, at the moment, up to the end of this year, if you are a UK or an EU resident company or individual, you will qualify for UK unregistered design just by virtue of being based here. There are some other countries that apply too, Hong Kong, New Zealand, and a few Caribbean islands, which is an attractive prospect, especially looking at the rain outside my window right at the moment. But basically, you have to be from one of those places. That's changing at Brexit. Without trying to give too much of the end of this talk away, if you're an EU 27 resident, you will no longer qualify through that route. There are still things you can do, and we'll look at that later. You also need to prove copying. With registered designs, you don't need to prove copying. You just need to prove that they've got something that's too close. With this one, you do need to prove copying. In some cases, that's just really straightforward. It's obvious that they've copied. And if it's too close, they have to prove they didn't copy, which can sometimes lead to some reasonably amusing stories being told about how they came up with a design that was so similar. Finally, you do have to just bear in mind that obviously it's a shorter period of time than registered designs, and you can't think about registering later because you've missed your chance after that grace period. So think at the beginning about your strategy. You need to have a plan. So making the most of unregistered designs. Establish early how you're going to qualify for the rights. Ensure your paperwork proves that you created and own the rights, and consider your launch plan to ensure that you maximize protection. Under both the UK and EU versions of unregistered design, there are ways of qualifying for the design by where you first market your product. So if you want a particular jurisdiction to be protected, then the best thing to do is to think about how and where you're going to do your launch. Now, for most of my clients, they would say that their launch plan is not going to be dictated by unregistered design protection. And that's completely fair enough. You don't want the tail wagging the dog. However, you do need to think about it a bit, because if there's something you can do to tweak your plan to maximize your protection, it might be worth it. And it may be cheaper or easier than going for lots of registered designs instead. The other final point is just keep a track of copies. My experience is that if you let those copies proliferate, everybody seems to think your design is fair game. And before you know it, you've got a huge enforcement program on your hand, or you decide it's simply too late. The best thing to do is to try and crack down hard on the initial few copies so that people go and copy someone else. Well, that's enough of a recap on designs and what they are. For those of you who are already very familiar with designs, forgive me for the recap. But moving on to the case that we did, where the judgment came out very conveniently 2 weeks before this webinar, and that's the case of Freddy and Hugz. With apologies for the number of times I'm going to say bum and bottom over the next 10 minutes or so, I'm going to go straight into what this case was about. My very young children think that it's hilarious that this is what Daddy does for a job. Introducing the Freddy Rupp jeans. The idea of the design of these is to accentuate the shape of your bottom. Inspired, I think, by Kim Kardashian and friends, our Italian client designed these products which work in a maybe more user-friendly way than surgery. And they have been extremely popular. I don't think they're intended for quite a lot of people, maybe the people who are on this webinar, but they are extremely popular, and therefore, inevitably, they have been copied. Here is the Hugz version, the Hugz Mark 1. The reason it was called the Mark 1 is this was when they first infringed Freddy. This case with this design was actually settled. They agreed that they would take it off the market fully by the end of April last year, 2019. However, on the 1st of May, or maybe the 2nd of May, 2019, they brought out a new design around. I think they thought they'd been awfully clever. Here is the Hugz Mark II. I'm slightly hesitant to do this, but I will do it. I'll just move on to a comparison slide. I'm going to get my laser pointer out now, and I'm going to point at different bits of the design. Now, this one here is the Freddy design, I think, and sorry, it's just because it's quite small on my screen. Yes, I think it is. And you can see here that this seam goes right to the middle. In the Hugz Mark 1, which is this one here, the seam did the same thing. Their wizard wheeze on how to avoid infringement, both of the patent and the design, was to remove that seam there. So that seam there was taken away and it was pleated instead. This, they thought, got them around the patent, but also around the design. Freddy was not happy with that, so it moved to bring proceedings against this second product, the design around. And it relied on 4 different claimed designs. Remember, we can define the designs at the point of the infringement, so so that's what we did. The first design was the shape of the jeans when they are being worn. The second one was the internal rubberized support panel. I'll show you that in a second. The third one was the shape and or configuration, that's what UK Unregistered Designs cover, of the inner parts of the upper rear portion of the garment. And finally, as an alternative to the first one, we relied on the shape and or configuration of the jeans when not being worn, the jeans on their own. I'll just show you what each of these designs is before we talk about what they consist of. This is the internal rubberized panel here, this bit here, and that creates a resilience which pushes up everything that's above it. The next, the inner garments, the inner parts of the upper rear portion of the garment, by the way, these are inside out, consisted of the 4 things on the slide. So to go through those designs in turn, the when worn design was perhaps the most controversial. When you have a claim for a design of a product, you are claiming the design of that product. If it's only going to take that shape, don't forget, we're only talking about shape, when it's worn by a particular person, that is less likely to be protectable. And so it was found in this case. The problem we had with this case was that the real innovation or real design of this product was when it was being worn by a person. But To do that, you need the person as an ingredient. And the argument was by the defendants that everybody is different, everybody's bottom is different, and therefore everybody's jeans would look different when worn, even if it is shapewear. We argued that actually the shape is the same, the size might be different, but the shape is the same in every scenario. But the judge wasn't having that. And he said that it was influenced by the shape of the wearer, and therefore it was not capable of design protection on its own. So we moved on to the next one, which was the alternative pleading, which was the jeans on their own. This was a more conventional design claim, but we felt the reason we put the jeans when worn in is that it's hard to tell from the jeans themselves. If I've got them here, if you look at them like this, it's very hard to see, if you can see that, what shape they're really intended to create. As this wasn't reliant on the human body shape, we got over the issue that we had with the when worn design. But where it was potentially, well, certainly in the defendant's view, slightly controversial, is that we claimed the elastic nature of the panels. Remember, unregistered design only covers the shape and configuration of the product. So we were relying on this as the configuration, a part of design right which is not always that well understood. But basically we were saying that the different panels together, the configuration of those panels, including their elasticity, created movement. And that movement was part of the design. There have been a few cases about moving designs, but not many cases have decided the point in a particularly clear way. And this case did. This case said that that was okay. The notion of shape and configuration is a broad one, and it should encompass the notion of movement. Now, this is really relevant to lots of companies, probably much more broadly than fashion or Freddy. If you've got a design for something, but really where the design becomes relevant is when it moves. It might be a pushchair, it might be an umbrella, it might be something like that. Those are all scenarios in which this case could really help you. The objection was that it's shape, and so therefore the material choice should not be relevant. But our claim wasn't to the materials, it was to the shape and configuration created by those materials. Now, there are various exceptions to unregistered design protection. There were 4. They threw the book at this one. They tried to rely on 4 different exceptions, which would basically say that if one of these exceptions applied, then design right does not subsist in this. And this is one of the problems, if you like, with unregistered designs, because there's a few more things that you can throw at it to try and knock it out. The first one is that the design consists solely of a method or principle of construction. This has 2 different types. One is that basically your claim is so broad and abstract that it's not really relating to a real product, and therefore it's a method of constructing a pair of trousers, and you're just throwing some things in there without being too specific about it. That was an objection thrown at these jeans. The other one was that it's a claim to a manner in which the article is put together. So it's a claim to just the seam or something like that. Now, in relation to the, let me just go forward to it. In relation to the rubberized support panel design and the inner parts design, both of which are shown on this slide, they claimed that all we were really doing was claiming the use of a rubberized support panel per se in the product. They said this was too abstract and therefore was not protectable. We said that that was not the case. We said that we were relying on not just any rubberized support panel, but this rubberized support panel as shown in this product. We said that the rubberized support panel in the defendant's product was, for all intents and purposes, the same, and that's why it infringed. It was not the fact that you have a monopoly over having a rubberized support panel at all. If you wanted that sort of protection, you'd have to go down the route of patents, which we did, but in a different way. So therefore, the judge found that that argument was not applicable here. The other objection to, on the basis of method or principle of construction, was on the jeans on their own design. That was about the fact that the elastic panels and the seams and so on were just about how the product was put together, not that it was too abstract, because it was the genes as a whole, but that they, but it was just about how you put it together. It wasn't about the shape or configuration of the design. And the judge said no. He said that misunderstood the exception for methods or principles of construction. He said that it's not, we weren't protecting those bits, we were protecting their application and the resulting shape and configuration. And that's why he said that that argument did not run and that the design was valid in relation to those bits. So moving on to the other three objections made, and I'll do this relatively briefly. The first one was must fit. It was quite a good reminder in this case of all the different things that you can throw at something, even if actually they were all unsuccessful in this case. Must fit is where you have something which is a feature of the design, which is only there to enable the article to be connected to, placed in or against another article in order to perform its function. So the two have to be next to each other in order to perform their function. This was argued in relation to the rubberized support panels. What they said was that they are flat, and the only reason that they are there is to fit against the genes themselves in order to perform the function, which was to push up somebody's bottom. This didn't get any real traction in this case because the judge said that it's not against another article. It is all one article. It is just the pair of genes. The idea of the must fit exception is more to do with having a spare part that has to fit against another product in order to perform the function. So it is the exhaust pipe on a car has to fit with the next part along in the production line, because otherwise it will not work. That's what it's really about. It's not designed to split at one article into its component elements, and that's why that point may be quite useful for other cases. The must match exception is similar but different. This is about where the features of one article are dependent on the appearance of another article in order to form an integral part. Now, the argument here was the genes were designed in such a way that they must match the bottom of the person so that they were skin tight effectively, and that they would both together form an integral part, an integral article. There is an open question in design law as to whether or not the human body is in fact an article. There was a case called Ocular Sciences a few years ago, which looked at contact lenses and eyeballs and whether or not must fit or must match applied in that scenario. We decided it was going too far to ask the judge to consider that question here. We said he didn't need to, because he was actually, all he needs to look at was whether or not the genes and the human body formed an integral part in relation to the scenario we were looking at here. And the judge said no, it was not. They were still two things and they were not designed to perform an integral part. So it's not like having one car door replaced on your car and it has to match the others, otherwise it'll look odd. It's different because when you put the car door in, you're creating a car. You and your genes are still two different articles. That argument would have been perhaps more interesting had they played it with the must fit exception, where they must fit against the human body, but I would still think that it would be unsuccessful. Finally, and very quickly, they argued that the rubberized support panel is something which is just surface decoration. That and the seams are just there on the surface to make the thing look pretty. There was one obvious fundamental flaw with that argument, and that was that we are, as on the screen at the moment, looking at the inside of the genes. So it's very difficult to argue that the inside of the genes could be seen as decoration. But perhaps of more general relevance, this argument that if something's really flat and therefore doesn't have much 3D shape, can it be anything other than surface decoration? Well, the judge said no. The fact that something is effectively 2D doesn't mean automatically that it is surface decoration. You could have a piece of paper that cuts out a pattern for something. That is still capable of design right. Just because it's flat doesn't mean that it is excluded as surface decoration. But it is a useful reminder that if something is on there just as decoration, it is not part of the shape and is therefore not protected. Finally, and very quickly, we looked at passing off in this case. I'm not going to talk about the patents angles of this case. They were relatively conventional. This is obviously off topic slightly, but it's relevant to product designers. If you create some features of your product that are characteristic, they're like branding elements, then if you rely on those, it may be that you can argue that a later infringer is misrepresenting to consumers that it's in some way associated with you. Now, in relation to this, the branding elements on your screen, the whole rear of the jeans, but also the crossed over belt loops and the enamel button on the fake pocket were features that Freddy had promoted very heavily when doing its promotion for this product. Jeans, as you will probably know, quite often, hopefully you're not looking too closely at somebody else's bottom when you're looking at branding elements. So these pictorial bits are really relevant and are quite often used as a way of recognizing a pair of jeans as being from a particular brand. The most notable example of that is probably the Levi's red tab, but you can also think of the Wrangler pocket and so on. This case is no different in that respect. We said that these branding elements were things that people would associate with Freddy if you were in the right consumer group. The other side said that these were not branding elements. And anyway, the person buying the jeans knew that they were Hugz because they either bought them from the Hugz website or they bought them, and they say Hugz on the inside and even on the belt loops. We argued that this was still passing off because people would have thought that the designs and so on were so close that they must have been an association, even if they were sold under a different brand. But also that as an alternative and slightly more unusual argument, there was what's called post-sale confusion in passing off. This was where this case was probably at its most interesting, in that the judge found for the first time in the UK, adopting some reasoning from a case we found in New Zealand, that post-sale confusion in passing off is an acceptable basis for attack. That is, the consumer that buys your product is in a conspiracy with you, effectively, to convince other people that it is that you're wearing the real thing. So this whole idea that that brands, you're buying into the look of the main brand, even though you've bought the copy, that could now be an infringement by the infringer, because they are misrepresenting to consumers that that product is associated with the main brand. And that could lead to confusion in the marketplace. I'm not going to go into too much detail because that's almost a topic in its own right, but I wanted to flag it as being a point of particular interest in this case. Now, I know you've been looking forward to the bit about Brexit, so let me come on to that now. Brexit and designs is an area which is particularly complicated, unfortunately, and I will try and simplify it as much as I can. You will recognize this from earlier. I've added a few annotations, but effectively, the design position as of now is this, but as of the end of this year, with a new regime coming in from the 1st of January 2021, changes things somewhat. So if we overlay the picture that we looked at earlier with the post-Brexit position, and I'll just do that now, you will see that there are some changes to the position in the UK post-Brexit. If I can just change my slide. Okay. As you will see, there's an extra there's an extra box and a ball, and a few of them have changed. Instead of having an EU registered design applying in the UK, because they will no longer apply in the UK is cloning EU registered designs and putting them on the register as if they were UK registered designs from the same time. Here you will see re-registered designs is what they're calling them. They are the formerly EU ones that are now coming into the UK. They will be treated the same as a UK registered design, but they will have all the dates and so on from when you apply to EU level. That's just to maintain your level of protection that you had previously. The EU registration that you had will still apply, but obviously it will only apply in the other 27 member states of the EU. So it's just worth bearing in mind that you will have both, but they're splitting into two bits, and you will have to pay renewal fees on both, I'm afraid. And if your renewal fee is coming up soon, don't think that you can pay this side of the new year and avoid paying the UK separate fee. If it would strictly have come in, the renewal date was after the 1st of January, I'm afraid you'll have to pay both. One other point to think about is if you have an application that is ongoing at EU level at the moment and it's not going to be published and granted by the end of this year, then you will need to reapply in the UK to maintain your protection. You have 9 months to do it and to maintain the original filing dates and so on that were deemed at the EU registry. So make sure you've done it, ideally early next year, because I think there'll be a bit of a crush on the registry in the end of September next year. The one important point for some of you is that if you've registered your design but you have deferred publication of that design, you have to make sure you've published it this side of the new year. If you don't, if it's not published before the end of the year, you will have to reapply for it in the UK. Now, the EU unregistered design protection system is changing slightly, and I'll just add a couple of labels to this to help you with that. For designs created before the end of this year and first marketed in the UK or the EU, i.e. EU unregistered designs that cover both the UK and EU, they are going to be split a bit like registered designs. So you will have a UK version called the continuing unregistered design. It will work in the same way, but obviously if you sued under it in the UK, it will only apply jurisdictionally to the UK, and your EU one will carry on. For designs created after the 1st of January 2021 and first marketed in the UK as opposed to the EU, you will get equivalent protection to the sort of protection you would have got under the EU protection, but obviously it will only apply in the UK. That is called supplementary unregistered design, and strictly you have to choose between that or the EU version. You can't, in theory, have both. Copyright stays the same. Now, the European position overall is slightly more complicated in that if you want to have protection as you do now in both the UK and the EU, you need to think about the fact that you will have community registered designs that you can apply for as well. And those community registered designs are you can apply for them even if you're British, and you can apply for UK and EU ones as long as you think about making sure that you don't invalidate one with the other. If you do my suggested system earlier of applying for lots of registered designs in the UK and then using that 6-month priority window to apply for your EU ones, that could work well, but you just need to make sure you keep an eye on your dates. The choice I was talking about or when looking at the previous slide between the UK ongoing version of the EU unregistered design and the community version is at the bottom left of this slide, and it is important to think about. There are some things to think about how you might be able to try both, but we're running out of time, so I will leave that to see if anybody's interested in that during the questions. The UK unregistered design position, the one at the top, the shape only unregistered designs, you will no longer qualify if you're an EU 27 business unless you first market your product in the UK. If you first market your product in the UK, you could still qualify for UK unregistered design protection. And if that's particularly valuable to your product, to your company, you might well want to consider that, because if you're not interested in EU unregistered design, first marketing your product in the UK may help you get a very valuable form of protection. Obviously, the other option is that you just register more designs than you were before. So summing up, because I'm conscious of time, what does this mean for you overall? Well, designs have always been a good fallback. They still are, but it's now even more important that you plan ahead. Lots of clients come to us thinking that they want to rely on their registered design that they filed, but actually the registered design isn't necessarily very good because they didn't seek advice on it. And so we end up falling back on unregistered design because it's there automatically and you just have it. But if you take a bit of effort to plan your unregistered design protection, then you will find that you're in a better position. The reason you'll be in a better position is if you document who designed it. Were they an employee of yours? Were they based here? Were you based here? Did a contractor help? That kind of thing. If you document that, even on one-page form at the beginning, then you will just find that when you come to enforce it 5 years later, it's that much easier and you will spend less money doing so. Also, you'll find that your designers and your people you've worked with are more likely to be happy to assign you the rights or to help you clarify the rights if you do it at the beginning rather than when you need them 5 years later and you maybe don't have as much contact with those people later on. I've already talked about launch strategies and I won't talk about them too much more now, but do think about them carefully to maximize the unregistered design protection if that's feasible in your business. And if it's not feasible in your business or anyway, do consider registration of your products and logos and other graphical works as designs, if you think that they'll be infringed. Obviously think about other forms of protection too, like patents and trademarks, but don't forget that designs can be used to protect graphical works. And with that, I'll be quiet and see if we have time for any questions.
Thanks, John, for that really interesting talk. So now looking at questions, we've got one about the EU and UK unregistered design position post-Brexit, which is, if you want to try to have both EU and UK unregistered design right after the 1st of January, can you publish first in both the UK and the EU? And the contributor has given the example of by putting it on a website in the UK and the EU on the same day. Because obviously a website would be able to be seen simultaneously in both places.
Well, this is spot on to whoever asked that question, because that is absolutely the question of the day at the moment. In fact, it's a question that I've been lobbying the UK Intellectual Property Office about, because the answer is that it's just not clear at the moment. In theory, what that question, person who asked the questions said is absolutely right. If you publish on the same point, so you publish on a website that is pointed at the UK and EU equally, my view is that that should be capable of protection for unregistered designs in both. The point is, though, that is not currently something that the courts have considered, and so it's unknown. What I've asked the UK Intellectual Property Office to do is to take the bull by the horns and say whether or not they, under the, obviously they can't talk about the EU position, but they can talk about the UK position under these supplementary rights. What will they consider under the law to be acceptable? So far, I've been brushed off by the UK IPO saying that they need to wait for a case to clarify it. And I'm afraid I'm not taking notice of an answer, so I'm going to be talking to the UK Intellectual Property Office about it a bit more, because I think that it's not fair on businesses to have to try and potentially fail, because if they do one thing and actually the other was the right answer, then it's too late to do anything about it. We need the certainty now, and I have got a few other people from the profession to be interested in this as well, and we're going to try and lobby the government to make some clarification on this. It may mean passing a statutory instrument in due course just to clarify the legal position, which obviously then would then be applied by the courts. But the trouble is, these cases don't come up that often, and if we wait for a case to come up on it, then we're going to be a little way down the line, by which time lots of designers have tried something and failed. So my strategy in the meantime would be, I wouldn't rely solely on that. I would rely on registered designs as well. But what I would be doing is, if you've got something where you really want UK and EU registered design, sorry, unregistered design, I would be based in the UK. I would try and do it from the UK, because then you get the UK unregistered design too if you don't already qualify for it. I would publish it simultaneously in the UK and the EU. And then if you don't end up with both, you're more likely to end up with the UK version than you are with the EU version. The EU one is, in my view, less valuable than the UK. But that really depends on who you are, what your market is, and where your biggest sales are. If your biggest sales are in Germany, you may not agree with that. And if you're in fashion, you may not agree with that, because the EU type of design with the 3 years, but covering every aspect of the design, is more relevant. So what I would say on that is, do it from the UK, but publish it on a website that's definitely simultaneous. So maybe upload it, from my view, upload it to an EU, UK aimed Instagram account or something like that, a third-party site that is clearly going to, it's not like you're putting it on your UK version of your website and the EU version of your website, and therefore there's some argument that there were nanoseconds of difference between the two. If you've got a pan-EU, i.e. it applies to the UK and EU website, where literally if you upload it to one, it's instantly uploaded to the other, and I mean instantly, then I think there's a good argument that would cover, you would get protection in both, because neither one can invalidate the other. That's my view, but be careful, because I don't think that can go too far. I don't think that would necessarily apply if you only put it on a website that was viewable from the UK or EU, but was aimed at US consumers, for example. I think you'd have to argue, a bit like some of the cases in trademark law, that you have a website that is directly aimed at people in the market in the UK and EU. There are other ways of doing it other than just a website. You can do it as a sort of live stream, or there are various things you could do. Even if you don't want to actually put it on sale on your website yet, you could have a preview or a live stream or something. But obviously it needs to be before you've disclosed it in real life in the country. So if you can't just do it, for example, if you were doing it as a film from I don't know, a catwalk show, if you had the camera at the end of the catwalk show and people were coming out on the to show the products, and your video was sort of a few seconds later, arguably it's been shown in real life in one or other destination first. So just think about that, but it's something to take advice on.
Great, thank you. And then another post-Brexit question, actually. So yeah, after the end of the transition period, should we be thinking about WIPO designs?
Yes, WIPO designs haven't been particularly popular. This is called the Hugz system. They haven't been particularly popular because of where they cover. They haven't covered some of the most important countries out there that you might want protection. Like, they've only recently started covering the US and Japan, and as far as I understand it, China still isn't part of the system, although it's on its way in. So it's got a lot better over recent times. I would definitely consider it now. It is sold as being a cheaper system. You don't even need a base registration. You can apply straight to WIPO, which makes it different to some other forms of international right. It's good because what happens is your design in one country may literally not be able to be registered in another country because the rules, the requirements of the different registries are such that actually some of them are directly opposite to each other. So in some, you're allowed the part of an article, and in other countries, you're just not allowed to protect part of an article. And there are other things to do with how you're supposed to show your graphics, your pictures, your representations, which are directly contradictory. The idea of the WIPO Hugz system is that it brings up the bar to a lowest common denominator, where those requirements are harmonized such that there should be a minimum level that if you comply with all the different requirements, you should be able to cover all the different jurisdictions, which is an advantage of it. If you want to go, for example, the US and Japan are very different in their requirements. If you want to protect in both of those, Hugz may be useful because it actually changes the requirements needed to get protection. So definitely think about it. Try and find we don't actually register designs here at Gowling WLG, but there are design attorneys out there who have done this before, and I would recommend you try and find one that's definitely done it before, because not all of them have, because it's not a new system, but it's newly popular, so not that many people have experience of using it.
Oh, that's a helpful tip. And then finally, in our last 2 minutes, we've got a question about, do you have any guidance on the kind of evidence that we should be building or retaining to demonstrate the kind of the necessary goodwill for post-sale confusion that you mentioned earlier?
Thanks, good question, and quite difficult to answer in 2 minutes flat. But really, it's about making sure that you focus on those elements that you're claiming are branding elements. Where a lot of these cases fall down is that you're just actually later trying to claim rights in your packaging with no real evidence that your consumers necessarily recognize that packaging as being linked to you. You might think it is because you've been selling it for years, but do consumers see that bottle shape and think, ooh, that is a Yakult or whatever it is? There are certain types of product where you really need to focus on that shape to make it something which is associated with your brand. Coca-Cola does it very well, obviously, with the Coca-Cola bottle. It is part of their advertising. Some of their advertising only has the bottle shape and doesn't mention Coca-Cola at all. With the Freddy case, there was lots and lots of marketing, which, yes, Freddy was written on the jeans and it was written on a lot of the posters and things like that. But a lot of people recognize the product just by virtue of the shape of the product. Oh, it's that product, not necessarily knowing that it was called Freddy. And that's the sort of goodwill that you will need to be able to do it. The same with the red tab. If you saw the red tab on Levi's jeans, then you would think Levi's, even if you didn't see the word Levi's. That's the kind of recognition that you would need in order to succeed. It's not easy, but if you've done it in your advertising and your marketing as you've gone along, it's going to be easier.
Great. And with that, I think you've brought us in on the nail of 11:30. So thank you to John, and thank you to you, everyone who's attended, for joining us today. At the end of the session, a feedback form will appear on your screen. If you have a few moments, please do let us know your thoughts on today's webinar. We really do value your feedback, and it helps us develop and improve these events for the future. We've also been recording the session, and we'll email you a copy, along with links of the previous webinars and details of our final session on copyright in the new year. So thank you very much again for joining, and we hope that you have a great rest of your day.
Thanks.